Well, hello, everyone, and welcome to One Civil Law, where, as always, we learn through the misfortunes of others. For today's stream, we turn our attention to the recent Omnibus hearing, which just means we're going to discuss multiple things. In the case of the state of Minnesota versus Nick Rekieta, primarily, we are looking to dismiss and suppress. We are not happy with the search warrant. We're not happy with the evidence against us getting that search warrant. We're not happy with the amount of it, nor the quality of it. Quality nor quantity is sufficient. We are concerned this search was improper, illegal, or otherwise problematic in some way, as we learned from the motion itself relating to this. As Nick filed his motion, Nick basically said a couple things. First of all, he said one of the people had a serious grudge against me, and that should have been disclosed. Another thing he said is that they didn't view the original video because I hid it. I made it private. Didn't delete it, didn't remove it, mind you, might have made it private. Okay, so they didn't view the original, so they're suspect. In fact, the video has a watermark on it that shouldn't have been there or wasn't there in the original. So the quality of the evidence is not necessarily great, according to Nicholas. Now, I will note, as I've noted before, that the standard here, of course, is probable cause, which is exceptionally low. You know, on a scale of 1 to 10, if 9.5 or 9.9 is beyond a reasonable doubt, and 5, by definition, would have to be preponderance of the evidence, well, it has to be less than 5 by definition. So what is it? Well, maybe 1 out of 10. Maybe it's that low. Obviously, you could quibble with the number, but the idea is more important than the actual number. But we understand what we're talking about, right? It is just basically objective indicia that indicates that this person has committed a crime. And it doesn't necessarily have to be as solid in terms of the evidence that's required in order to do that. We can do hearsay, we can do hearsay upon hearsay, we can do that kind of thing because the quality of the evidence doesn't need to be high because the standard we're trying to meet isn't high. The quality and standard kind of run parallel. Obviously, we could use higher quality evidence, that's fine, but we're only trying to reach a 1 out of 10 standard, so 1 out of 10 evidence will typically be fine. So, you know, that's fine. So we turn our attention to this hearing in which Nick is going to raise these issues and discuss it. I have not read this before, but we'll read it together and see what it has to say and see what the arguments looks like and try to reassess the probabilities. So far, I'm not very optimistic on Nick's possibilities here. I think that Nick's very unlikely to get this to win, but we'll see if, you know, the argument changes it or makes the calculus change as we go. So we'll see. Anyways, we've got Kristen Pierce, who is here for the county. We got Francis White, who is here on behalf of defendant. And of course, Nicholas here, who is also here. So this is Nick's omnibus hearing, not to be confused, presumably, with his wife's omnibus hearing, which might happen at some later time. The court will call court file 34 CR 24-341, State of Minnesota versus Nick Rekieta, who does appear with the attorney Francis White. Kristen Pierce and Jordan Engler appear on behalf of the state. The matter set for omnibus hearing here today. Mr. White, do you have some contested issues? Yes, Your Honor, we do have contested issues. Okay, I would ask that you remain seated since we can pick you up on the mic much better. No problem, Your Honor. Yes, Your Honor, and if it may please the court. Solid. On Sunday, we filed a motion asking for this court to strike all evidence, to suppress all evidence that was collected under the warrant. We based our motion on the two-prong test in Franks, a case in which I'm sure the court is very familiar. Yeah, Franks is one of those backbone cases when it comes to searches, so kind of comes up a little bit, as you might expect. It's pretty frequent. Yeah. Under Franks, there's a requirement that the statement is made by the reporting officer was false or reckless disregard of the truth, and the statement was material. Correct. That is essentially the standard. You can't lie. You have to disclose. You have to disclose any fact that would be going the other way that you know about. So you can't make up stuff. Everything you say is true. Everything you say has to be true. You do have to disclose any evidence that you happen to know about that goes the other way. And if you do lie or misrepresent, the lie has to be material in some way. Cool. In order for it to impact the warrant. Cool. As indicated in the motion that we filed, I believe that both of the legs upon which Deputy Pomplin, I believe is his name, based the motion or based his request, I believe they're both faulty. As I pointed out in the first instance for the warrant, he based that on hearsay, which I concede is admissible, as I said, right? Because hearsay is admissible in a probable cause. But hearsay from a reporting official a mandatory reporter who reported something to another officer, that officer, Sergeant Nestor, forwarded that information to Candidato County and Human Services CPS, and CPS rejected that, which is true insofar as it relates to the child abuse issue, but that isn't why we got the warrant. See, if we got the warrant because we're looking for evidence of child abuse or child neglect, then if CPS said, hey, we don't think there's evidence of child neglect here, or our investigation says there's not, then yes, the officer would be required to put that in the warrant, which doesn't necessarily mean that the warrant won't necessarily issue anyway, because maybe there's evidence beyond what CPS considered, or maybe CPS has their head up their ass, right? So just because CPS says a thing, either way, incidentally, doesn't make it true. CPS could have their head up their ass either way. They're like, yes, there's totally child abuse here, but there's not. Or there's not child abuse here, but there is. But either way, if CPS tells you, hey, we don't think there is a problem, that's the kind of thing you need to disclose in the warrant application. But you only need to disclose it in the warrant application if you were searching for evidence relating to child abuse, because then you have evidence that goes the other way that you know about. You have a conclusion from a competent government official who says, no, we don't see it. So then you're like, yes, I disclosed that. And by the way, here's all the reasons that CPS is wrong. And here's all the other evidence that goes the other way. So what do you think, Your Honor? Do you think there's enough evidence or not? Right? That's what judges are for. That's what judges are for. Judges make the final call. CPS has an opinion. The police has an opinion. Other people have an opinion. The judge makes the final call. That's what they're for. But you have to disclose that. But you only had to disclose that if you're searching for evidence of child abuse, child neglect, but you weren't. The evidence that the warrant by its own terms is searching for evidence of drugs. So the only evidence that you'd have to disclose would be evidence relevant to that search. So CPS's opinion relating to child neglect is kind of neither here nor there on that issue. So I don't know why it needs to be mentioned. That's what I think. The latter estimate, and also, of course, by the way, as I sort of said in an earlier searches, investigations mature. So it could be, of course, the case that the pastor initially came on child abuse, child neglect charges or concerns, because that would make sense. The pastor in this state is a mandatory reporter. Clergy are mandatory reporters in something like 20 states. So the list, not every state, but something like 20 states they are. Minnesota happens to be one of them. So if in Minnesota, if a pastor, priest, clergy of some description is aware of abuse against a child, let's keep it simple, then they are required to report that. Incidentally, of course, as you might be interested, the law on this has changed. That didn't used to be true, where pastors, priests, and clergies had to disclose. But that largely changed, although not entirely, but largely changed as a result of the Catholic abuse scandal. A lot of states, as a result of the Catholic abuse scandal, were like, you know what would be a really good idea? Maybe if priests were required to report the abuse to children instead of necessarily keeping it in-house. So if you're curious on the impetus for the legal change, that went a long way. But sure, either way, right, they have a duty to disclose. But that might have been the initial impetus, but that isn't necessarily where things stopped. The police might have gone investigating child abuse, child neglect, and along the way found evidence of a different crime, which if they did, then that's fine. And then they can choose which crimes to investigate or not, depending on their own priorities, because they're the prosecutors, or part of the prosecution at least. So they choose to kind of follow the investigation wherever it goes. So they're investigating one crime and then they discover evidence of a different crime and then they investigate that for a while. Cool. We didn't find a lot of evidence on the child neglect. Cool. But along the way, we found some evidence of the drugs. So just because the initiation of the investigation may have related child abuse, child neglect, doesn't necessarily mean that's where the investigation stopped. Just because the priest went initially with, I'm concerned the children are being neglected, doesn't mean that's where that stopped. And apparently wasn't where it stopped, because eventually they got a search warrant for the drugs, which is different. So, that's notable. Okay. The letter that I submitted as an exhibit clearly shows that the first artifice was rejected by Candeo High. As it relates to child abuse, child neglect, that appears to be true. Although strictly speaking, of course, ultimately that would be a decision for the judge. CPS's opinion is interesting and all, but not necessarily dispositive. Because, you can be like, no, I think they're wrong. And if you have enough evidence, then, fine. Either way, incidentally, they can be wrong either way. That's why we have courts to adjudicate things. But even if it had been rejected, the plain language is what is alleged in his request. His application doesn't rise to the level of anything to do with drugs. Child endangerment, perhaps. I'm not sure I see it that way because the warrant seemed to be based on the drugs, but okay. The language in there reflects nothing but child endangerment best, and I'll even concede it doesn't do that. Well, no, I don't think I necessarily agree with that. I mean, the issues relating to the children not being washed properly or clothed properly or not being fed properly is potentially evidence of child neglect, obviously, but it could be evidence of something else, right? So the children, because the warrant talked about the children, not their clothes not being washed or their clothes being dirty or them being hungry all the time. It's like that might be indicia of child neglect, but it might also just be issues that there is something else going on. For example, the parents are being distracted by their drug use. So I don't necessarily concede the point. I mean, child abuse, child neglect, child endangerment can obviously be a charge unto itself, but it also can be evidence of a different charge. So it can be the end, but it could also be the evidence towards an end. So I don't necessarily agree with that characterization, but okay. The second element is that Deputy Pomplin said he watched a video on Steel Toe morning show by a gentleman by the name of Aaron M. Holt. Aaron M. Holt and the defendant have I don't want to say a long-standing feud, but it's gone on for months. They don't like each other. It does appear based on my understanding that things are not necessarily going great as it relates to their relationship between each other. That does seem to be true. They plain old just don't like each other. And from writing in the particular application, it seems as if the deputy identified Mr. M. Holt and his exploitation. There's almost a concerned citizen. Okay. But okay, this is also interesting too, because to the extent that the cop would be required to disclose that M. Holt is biased, to the extent that they'd be required to disclose that, they'd only be required to disclose it if they knew that. So if they don't know that, they don't have to disclose it. The case law is fairly clear, right? In a search warrant, they only have to disclose things they actually know about. So whether or not there is actually animus or not, the cops only have to disclose if they were aware of the animus at the time. And even then, the question would be like, do they have to disclose it? But they would only have to disclose it if they knew about it. And if they didn't know about it, then they wouldn't have to. So if they didn't know about it, then they don't have to disclose it. Well, the case law is very adamant that he doesn't qualify as a concerned citizen, because when you're dealing with the concerned citizen analysis, you look at what the motivation is. The motivation is important to determine whether someone's a concerned citizen or not. I'm not sure that's necessarily completely true, but okay. Also, the video, and stated in the evidence, the video he watched couldn't have been the defendant's. Well, it could have been, just not necessarily from the defendant's site proper. In fact, the evidence that we've received in discovery in their supplement shows a clip from presumptively the video that he watched, showing it came from a different platform, and a different platform added elements to the video, such as the watermark. I mean, come on, in my opinion, come on. So the video in and of itself is not reliable. Well, for trial, probably true. For trial, we're going to want the original. It's the best evidence rule, or its variance under state law. We want the best. We want the original. We don't want to hear about it from a guy. We want to hear about it from you. We don't want to see a copy of the thing. We want to see the original. And so forth and so on. We want to get back to the primary material to the best extent possible. That's the best evidence, is going to be the primary original, right? So yeah, but for the purposes of a probable cause, So the video itself is not reliable. And the problem is that deputy didn't identify to the judge. It's my belief that if Judge Fisher had known the allegations were made and being evaluated and dismissed, and the video was not, that Deputy Pomplin reviewed was not Mr. Rekieta's video, but was in fact a video that someone else had copied and had elements to, like the watermark, that she would not have issued the warrant, at least not in the 4 minutes from the moment she, from the 4 moments she signed it and then signed the warrant. 4 minutes elapsed between the application and the warrant. Well, be that as it may, judges often rubber stamp warrants, as you might expect. So, yeah. I assume that all judicial officers take their jobs and responsibilities seriously, and in doing so, they rely on officers of the law to be honest and fully forthright and fully forthcoming in their expressions to the court. I think in this case, there are material omissions that Deputy Pomplin did not tell Judge Fisher about, which renders the warrant invalid. I don't think so, but okay. One of the other issues that I raised was the fact that the warrant, if the warrant is valid as to drugs, the police seize firearms, or alleged firearms, I should say, lol. We're not even sure whether or not they're firearms or not. I appreciate that. From Mr. Rekieta's residence. Those firearms are not listed in the warrant. There's no indication they were looking for firearms. The case law I cited in the brief, and I won't go over it here, is pretty clear that even with something in plain view, it has to be related substantially to, or there has to be a nexus behavior between the alleged offense for which the search warrant was granted and the seizure of the item not listed on there. There's no nexus here. There's not substantially related, and there is no nexus here. The case law is pretty clear. The third issue that I raised involves Miss M. Holte's statement to the officers after she's Mirandized. There's a lot of confusion about this. I would think so, because it didn't make any sense. It didn't make any sense to talk about her failure to be Mirandized, which is what that section talked about. Okay, the motion itself was styled, that is titled. Okay, the motion from Nick was styled, that is to say titled, as partially a motion to suppress, a motion to dismiss, and a motion to suppress. That was how it was titled. That was how it was styled, okay? And then they get to, okay, the statements from April should not be admitted to against defendant, all right? And then for like 3 paragraphs straight, they talk about Miranda and the failure relating to Miranda and the fact that the police apparently or allegedly violated April's Miranda. Okay? That's an issue relating to suppression. That's an issue relating to suppression, right? The statements were obtained in violation of Miranda. You can't use them. They need to be suppressed, which is how the motion is styled. Okay? In the very last sentence of that section, they start talking about the right of confrontation, which doesn't make really any sense. Okay, the issue dealing with confrontation is a different constitutional right. The issue relating to Miranda relates to your right to remain silent, which is your Fifth Amendment right. The issue of confrontation relates to your ability to see them and hear from them in trial, which is a Sixth Amendment right. So they're different constitutional rights. Also, it doesn't make any sense to bring up a motion to suppress in a motion to dismiss, because they're different things. You would bring it up in a motion in limine, but it wasn't styled as a motion in limine. It was styled as a motion to dismiss and a motion to suppress. So, and then they start talking about Miranda, and I'm like, oh, I'm interpreting this as a motion to suppress because that's how it's styled, and it doesn't make any sense. So if the issue was suppression, or I apologize, if the issue was the right of confrontation, it was very poorly written to that effect. It was very poorly written as a motion to prevent confrontation or a motion to exclude relating to trial, which I don't think we're necessarily near, and confrontation. But as far as it goes in sort of the right to confront, then sure. I mean, it's hearsay. Of course, if the statement from April implicates Nick and it's being offered for the truth of the matter asserted, then it's hearsay. It's hearsay. right, is a statement out of court being offered for the truth of statement, and it's being used against Nick, not against April. If it were being offered against April, then she's a party opponent, right? It would be state versus April, in which case she's a party opponent because she's on trial. So since it's a statement from a party opponent, it's considered not hearsay. But since it's state versus Nick, it's not a party opponent because she's not in trial with them right now. So it's hearsay. So it's a hearsay problem, plus it's a right to confront problem. He has a right to obviously hear from it herself. So yeah, of course you would exclude it at trial, but it doesn't belong in this motion. And so if my legal analysis relating to this was incorrect in some way, it was incorrect because it was very, very poorly presented. It was only incorrect because it was exceptionally poorly presented. It was presented, styled, titled as a motion to suppress, a motion to dismiss. And they start talking about Miranda, which is obviously a suppression issue. It's a suppression issue. Don't allow this to be brought against me, Your Honor. Suppress the evidence. Don't allow it to be brought against me. Right of confrontation is a totally different constitutional right. If I was confused, it was because they confused me. Oh, and Dave Hill says it's still valid for the warrant. That's the other reason that it doesn't make any sense, and I'm so glad you reminded me of that. It also doesn't make sense in the motion to suppress and motion to dismiss. It doesn't make any sense in the motion to suppress and motion to dismiss because the statements can't possibly be relevant to the search warrant because they didn't happen yet. That's how time works. So the other reason it doesn't make any sense is because the statements of April were only made after the search warrant already happened, right? The police have already shown up. They're already there. They're already doing their thing. April is there. She's taken under arrest, and then she makes the statement. Okay? So it can't possibly be relevant to the motion to dismiss, and it can't possibly be relevant to, anything relating to the validity of the search warrant because it wasn't evidence used to obtain the search warrant because it hadn't happened yet. It hadn't happened yet. It can't possibly be something the police relied on, can't possibly be part of the basis for obtaining the search warrant, can't possibly be relevant to the search warrant because by the time the statements were made, the search warrant has already been executed. It's already been executed. The statements hadn't happened yet. So it doesn't make sense because that's how time works. Oh, man. Jeez. The court, I'm going to stop you there. That third issue, though, isn't it more of a motion in limine? See, that's literally what I just said. Didn't I just say the motion's motion in limine? It's nice when I get there first, right? As part of my little rant, didn't I say this makes much more sense as a motion in limine rather than a motion to suppress? Didn't I literally use the words motion in limine? I did. I did literally use the words motion in limine. And now the court is using the words motion in limine. Doesn't that make more sense? It certainly does, Your Honor. Yep, that's what I thought. Nathan Lawyer gives $20, say the confrontation clause is not a win. It's obvious. It's an obvious conclusion. If April's going to testify against Nick, he gets to confront her. She may not want to testify, but the state can offer immunity, forcing her to. Yes, that's true. It's also a little premature. We have no idea whether or not April will testify or not at trial. It's also just a little premature because we're not there yet. And the state can give her immunity. They could give her use and derivative use immunity, which would solve the problem, so that they can't use the statements that she makes at trial against her, but could still prosecute her. Immunity comes in two forms, by the way, in case we want to learn something legally. Immunity comes in two forms. Immunity comes in what's called transactional immunity, and it comes in use and derivative use immunity. Transactional immunity is where we're immunizing you for the transaction, which we mean the criminal transaction. The criminal transaction is the crime or series of crimes that is closely related in time and or purpose. So it's a little bit of loose definition, but it relates to everything. It relates to all the crimes that are part and parcel and contemporaneous and closely related for the thing. So for example, if you went to rob a bank and you stole a car to rob the bank, the theft of the car would be part and parcel or part of the same criminal transaction, right? They're distinct crimes, but they're part of the same, they're closely related in time, closely related in purpose, and therefore they're part of the same transaction. So if we gave you immunity for the transaction, we wouldn't be able to prosecute you for any of the related crimes. But the Supreme Court long ago ruled that we don't have to do that. We can just give you what's called use and derivative use immunity, which means that we can't use your statements or any evidence we obtain on the basis of your statements, anything we derive from them. So the statements are immunized and anything derived from them is immunized, but we can still prosecute you if we have evidence independent of that. So that's, yeah, so they could do that, but it's also premature. We're just not that far along yet. Anyways, the court uses the words motion in limine because, you know, that's what I said. Because, you know, yeah, I'm going to stop you there. That third issue, isn't it more of a motion in limine that were reserved for the matter if it did get set for trial? Yeah. I'm not really sure it's proper for me to discuss at the omnibus. The judge is just saying exactly what I just said just now. It's like, it's always validating. It's always validating as a legal analyst when you say something and then like the very next thing the court says is what you just said. It always makes you feel a little bit smarter. It's like, I literally just said this and how the court is just saying exactly what I just said. It almost exactly the same words. It validates me. I appreciate it. I'm not sure if it's proper for me to discuss an admissibility or an omnibus, you know, discuss admissibility since it's not a constitutional or legal issue. It seems like more of a motion on limine is what you're suggesting on the last issue. Okay. You're right. That was my initial thought, Your Honor, but the case I cited, Souter, seems to end up with the issue being harmless error because, again, this is something I'm drawing from my research. And it doesn't state explicitly because it wasn't raised early enough. So belt and suspenders, I want to make sure that's raised as early as possible. Okay, fair enough. So he's concerned about the issue being preserved, so he wants to raise the issue as soon as possible. Fine, I appreciate that. Feels premature, but fine. And the state has conceded, and I'm sure Ms. Pierce will tell you, that they will not use the body cam footage that I'm asking the court to preclude unless Ms. April Holte testifies. With respect to her statements as it relates to Nick, then sure, they wouldn't use that portion of it because, again, that would be offered for the truth of the matter statements. It's a statement from a different person, and you wouldn't be able to use that. So that makes sense. That would have to be excluded. I get that. Okay. Thank you, Your Honor. All right. So summing up your first issue, then, you're essentially asking for a Frank's evidentiary hearing, and you've mentioned some items you placed in the MNDES. Just one moment as I refer to those. That was, well, do you detail what the exhibits are? It looks like you have some video recordings, the document image, a letter from Family Services, the application for a search warrant, and another video. Does that sound correct? There are, in there, I'll get rid of the two easiest ones to get rid of because there are two body cam videos because Ms. Pierce is conceding that is not necessary, and those relate solely to the third issue I've raised. Those are not particularly relevant. The other video I have is a copy that personally downloaded of the Steel Toe Morning Show. Steel Toe Morning Show from May 22nd, 2024, because it was their morning show, not the evening show, because apparently there's an evening show as well. I downloaded that. And the video reference to the times are that in our motion. The application for the search warrant, of course, was to the court that already had that, but it was for ease of use. The letter is a letter that I referenced from Candido County Human Health and Human Services, stating they investigated the report from May 16th, and they found it wanting for any evidence of child abuse or neglect, which is a pretty low standard. Yes, it is a pretty low standard. Again, probable cause is basically the standard. It is an exceptionally low standard. I agree. Candido County, apparently Child Services, didn't find it in their investigation. Which may or may not mean it legally exists, of course, because ultimately that's a decision for a judge, but they apparently didn't find it. Fine. The PowerPoint presentation is titled rekietavideo.pptx. That's a PowerPoint presentation that Deputy Pomplin references in Supplemental Report 1, which also included they created from someone else's stream, not from Mr. Rekieta's stream, but from someone else's stream. And the rekieta.png, that's a screenshot taken from the stream. Okay, and I already mentioned the supplemental report, and I think that's everything, Your Honor. What I'm saying is that the evidence is not the best evidence. That is a technical term, best evidence. And he's right, it's not. Right, best evidence is a technical term. Best evidence means as close to the original as we're capable of getting. We want the original thing. That is the best evidence. We don't want to hear about it from a guy, we want to hear about it from you. We don't want to see a copy of the tape, we want to see the tape. We don't want to see a copy of the photo, we want to see the original. And so forth and so on. Assuming, of course, it's available. Assuming, of course, it's available, because maybe we don't have it. Maybe it's been lost along the way. In which case, the best evidence by definition is whatever we have left. So if all we have is a copy, then a copy will do. Of course, we'd have to disclose it's a copy so that the jury will know that, so they can factor that into the analysis. So we can't hide from them that it's a copy. But if it's the best evidence, then it's the best evidence. The best evidence is as close to the original as we happen to have. So yes, it is not the best evidence. I agree. As a technical term, it is not. But for the purposes of this motion, I'm not sure that it needs to be, because, you know, best evidence is kind of a rule that applies at trial, and that's, again, premature. It is not the original evidence. And the Judge Fisher, had an expectation she would have been informed of that. Deputy Pomplin did not inform her of that. In fact, his application indicates if he watched Mr. Rekieta's stream and seeing that was only suggestion there were drugs in the house, then she had a duty, she had a need to know, and he had a duty to tell her that had been edited so she could have evaluated that. All right, Mr. Pierce, any objection to the court receiving these items? Miss Pierce. Your Honor, I would object to the video of the Steel Toe Morning Show. The affidavit for the search warrant does indicate that they did review a video blog on 5/22/24 from Aaron Imholt, but there are, as Mr. Francis White says, there are multiples per day. I don't know if this is the one that was watched, and I can't speak to the authenticity of that video. All right, any further responses on that issue? Your Honor, we're not submitting it for the truth of the matter here. We're submitting it as an indication there was a different video than what was actually reviewed. But excuse me, that Detective Pomplin watched the show, and the show indicated that there was animosity between the two parties. If you grant us an evidentiary hearing, the Frank's evidentiary hearing, I am certain we'll be asking Detective Pomplin whether he watched the video or not. So yes, a Frank's hearing would be ultimately where this would go, right? If the court finds there's enough evidence for a hearing as to explore this, then you might have testimony from some of these people on the stand as exploring whether or not this was proper or not. But, you know, Frank's hearings are very, very rare. They're very rare. And they usually relate to more serious problems than this. They would usually relate more to the cop have active knowledge that there were not drugs in the house, you know, because someone was in the house and like, I looked everywhere and there were no drugs, Your Honor, you know, that kind of thing. But this all seems this doesn't seem in the sense of being sufficiently concrete to warrant a Frank's hearing. You know, Frank's hearings typically rely more of an explicit or direct contradiction, you know, rather than, you know, it could have been phrased slightly better. So this seems a little bit weak, in my opinion, for a Frank's hearing, but, you know, okay, that's what they're asking for. All right, well, I'll take the admissibility of that under advisement. I'll review it and determine whether a court will overrule the state's objection. Ms. Pierce, Your Honor, would ask for to do a written response. All right, how much time? If I could have till the 30th, Your Honor, that'll be fine. August 30th. Okay, so the state is going to file a written response on this issue to deal with it, so fine. So they have 3 more days to file their response, in which I'm sure they will kick, you know, their teeth in, or at least try to. So we will cover that, of course, whenever it comes in. And that will be fine. All right, let's see what else we got. All right. And then it says, Mr. White, Your Honor, it asked to be reply to the written response. I have an additional 5 days. Any objection? Typically, this is your motion. I'd have you file your submission first and the states after. My submissions, Your Honor, are already filed. All right. In light of that, I'll allow a reply brief by September 6th. Okay. Yeah. So they already filed their thing. The state wants to do a response and they want a reply. Okay. So that's fine. The state files on the 30th. They file their reply on the 6th. The court enters its decision at some point following that. So fine. All right. In light of that, I'll allow a reply brief by the 6th. Thank you, Your Honor. All right. The court will take the matter under advisement as of September 6th and issue an order. Typically, an order will be provided within 30 days of that date. So we may not have a decision on this issue until October. So, fair enough, because sometimes they take time. Was there anything? I mean, this is normal, right? Things take time. They can be slow. And then, of course, the thing that would presumably issue at that, assuming that they were going to go Nick's way, the thing that would be issued would be an order for a Franks hearing. Would be the thing that would issue. The court would probably not be like dismiss it right out of hand, right? Because there's not evidence really to warrant that. So the best that you're looking for is an order to have a Franks hearing, which would be unusual. It would be unusual, so you wouldn't expect it. Typically in this, especially in this kind of fact pattern, because again, you don't really have the sort of massive contradiction that you might otherwise expect for. Was there anything else for your day? No, Your Honor, except for Miss Pierce, staying on the record, she did agree that the third element would be, she agreed that there would be no use of the body cam footage unless April M. Holdy testifies. Miss Pierce, I agreed there be, I cannot use April's statements unless she testifies because they're hearsay. Didn't I say that? Didn't I say that? It's like, yes, they're hearsay. They're a statement offered for the truth of the matter asserted. And Nick is not a party opponent with respect to the statements. So yes, they're hearsay. So yes, it's like, yes. Again, it's nice when you get there first. Makes you feel better as a legal educator. It's like, yes, that's the correct answer. I cannot use April's statements unless she testifies because they're hearsay and would not show her statement on the body camera. I'm not agreeing I wouldn't use any of the body camera. All right. Well, nevertheless, these are motions in limine. You've noticed it. If there's an issue that does matter, it'll go to trial. If there's any further contest, we can discuss it further as well. So the judge basically says, this is not appropriate for this hearing, which is true. I agree. It's way premature. It's way premature. We don't know whether or not April will take the stand or not. It's premature for that. We don't know. So yeah. So the judge is like, okay, well, these are really motions in limine. And so you've noticed it. Cool. And if we ever get to scheduling this thing for a trial, then you can feel free to bring it up in a motion in limine at that time, because that would be when it's appropriate. Yeah, that makes way more sense. All right. Understood, Your Honor. All right. Very well then. This court will take under advisement. I'll issue an order once the briefing's been concluded. Thank you, Your Honor. And that is the end of the transcript. Yeah, that basically makes sense. So the argument is kind of exactly what I expected it to be based on the briefing. And yeah, so the issue fundamentally is did he lie about anything? Did the cop lie about anything? Or did the cop fail to include anything he would have to include, such as evidence he would be aware that would tend to either indicate Nick didn't do it, or indicate that, well, just that Nick didn't do it really for the purposes of this hearing, because it's just a probable cause hearing. So to indicate that he didn't do it. And did he exclude anything along those lines that is material? And to my mind, the answer is no. I don't think so. The warrant application, the affidavit said the evidence was removed. And it's like, well, it was really rendered private. I'm like, well, removed could just simply mean removed from public view. It was removed from my ability to get it. And also, as far as it goes, it's like, it would be just like a basic slip of the tongue at best. It's like, okay, I should have said maybe rendered private instead of removed. But it's such a small distinction. It's like a distinction without a difference. Were they aware that there was in hostility, and should that hostility have been disclosed? And even if it had, like, there was other evidence that sort of rendered the thing. Because the thing is, like, the video is the video of Nick, right? So the problem is, it isn't just Aaron describing it. It is also the video of Nick showing the thing. Now, it's a copy of it. It's not the original. It's edited, but it's still more direct evidence than merely Aaron's report of it. So I would think that, and also the evidence, was being shown for this proposition of, that Nick went away to the bathroom, and when he came back, he was acting in ways that appeared to show intoxication, and according to the officer, showed multiple drug intoxication based on his observations. And so, that seems to be sufficient to show that the nature of the edit doesn't appear to really relate to that conclusion. So I don't think that this motion works. I don't think it works, but fair enough. He's doing his best to represent his client, as he should. So I'm still not very positive on this motion, but fair enough. I mean, he's definitely trying to reach for everything, so I'll give him as much credit as he goes, but I don't really see it. So yeah. So what is going on? So I'll answer a couple of questions if you have any questions or thoughts about this. Problem with that alone being the video, the cop's observation means a hill of beans if they can't be used to prove anything. People make BS videos all the time, after all. Well, okay. I think you might be making a mistake, which is fairly common here, because you say that the video doesn't prove anything. This is a bit of a mistake, because people seem to be under the impression, for some reason, that there needs to be evidence which unto itself proves the thing, which there doesn't need to be and is not typical. So does the video in and of itself prove something? Well, what you mean by that is, does the video in and of itself prove beyond a reasonable doubt? Or even, does the video by itself reach probable cause? Then my answer to that question would be no, it doesn't. So if your question is, or if your comment is that the video by itself doesn't prove it, then I would agree. The video by itself doesn't prove it. But that's not the issue. It doesn't have to prove it. It only has to be evidence of it. Right? That's what we have rules of evidence for, is because it has to have evidence of it. And evidence, by definition, either makes a fact in dispute more or less likely. That is what evidence is, by definition. So the question isn't, does the tape prove it? Because I would tend to agree with you. The tape alone does not prove it. The tape alone is not even sufficient by itself for a probable cause. I would agree with you. But you don't need to prove it. You just need to have evidence of it. And then the question becomes, is the amount of evidence in its combined accumulated form, is it enough to reach the standard we're trying to reach? Whether it's ultimately beyond a reasonable doubt, or for the purposes of our present exercise, does it reach probable cause? To which my answer would be yes, it does, but only in its accumulated form. So I think you might be making a mistake, because people say this. They're like, this doesn't prove it. And it's the exception in law. It is the exception in law, not the rule, that there is a piece of evidence that proves the case unto itself. That is the exception. So, yeah, I mean, technically, but it's not what we're trying to do. We're not trying to prove it. We're just trying to find evidence that is sufficient to, in its combined and accumulated form, sufficient to reach the legal standard we're trying to reach, which for the moment is probable cause, which is exceptionally low. And so, does it prove it? No. Is it evidence which in combination reaches the probable cause standard? I'd say yes. So that's what we're trying to do here. Yeah, relevant probative evidence. Well, to be relevant by definition, it has to make it more or less likely. Yeah, that's what makes it relevant, is that it makes it more or less likely. A fact in dispute, more or less likely. So does the tape make it more or less likely that there are drugs to be found in the house? I would tend to say yes, it does. The tape alone can be evidence of anything, but is it some suggestion that there's drugs in the house? I think it's some suggestion that makes it more likely. So I think it's evidence. I think that's true. So if the video evidence is enough, you just add the detective saying it's drug use? No, I wouldn't say that either. I would say that the affidavit, it provides an accumulation of a lot of evidence that might be suggestive of drug use by him. For example, that people spotted what they believed to be track marks on his arms. Now, they may not have been track marks, but people thought that they were. They thought they spotted something they thought to be track marks. That's some evidence. We have, the issues relating to his kids not being cared for, or not necessarily, that might suggest evidence of drug use, and so forth and so on. So it's accumulated, combined totality that is the right thing. That's not evidence, that's gossip. You misunderstand what evidence is then. So, and also, yes, it is a little gossip, but by gossip, you mean it's hearsay. And as I pointed out, for the purposes of a probable cause, for a search warrant, hearsay is allowed. So if by gossip, you mean it's hearsay, because gossip is not a legal argument. Gossip is not a legal argument. So if your argument is hearsay, then sure. But as even defense counsel notes, you can have hearsay in a probable cause. You can even have hearsay upon hearsay in a probable cause if it's sufficiently reliable. So, yeah. Hearsay equals police busting down your door and taking family. Why would anyone be in favor of that? Well, you might partially misunderstand me. So I'll try to clarify. Again, the issue is not any one piece of evidence. So, and this is kind of what I've said since the very beginning. I said this all along from the very beginning. So what I'm saying now is pretty consistent with what I said before. Like, you can attack any one piece of evidence in this search warrant affidavit. Like, if you put your thinking hat on, you can attack any one piece of evidence, right? But the problem is that you really have a very difficult time attacking enough pieces of evidence for it to matter, because you're trying to reach such an incredibly low standard. So, like, it's not enough that the video by itself, it's not enough that the police officer reached the conclusion it's drug use. It's not enough that people thought they saw track marks. It's not enough that the kids weren't being cared for, right? None of these things is enough. But the question is whether or not these things combined are enough. That is the question. Incidentally, that's the same question at trial. You're just trying to, the only thing that really changes at trial is, what does enough mean? That's what changes at trial. What does enough mean? But the same thing is, like, it doesn't have to be enough by itself. It very rarely is enough by itself. You can attack any piece of evidence by itself. You can dismiss any piece of evidence by itself. You can do that at trial too. But that's not the question. The question isn't whether or not you can attack or undermine a piece of evidence. That isn't even the question at trial. The relevant question is whether or not you can do it enough for it to matter once you are trying to consider it within the framework of what does it mean for it to be enough. And, again, at trial, the standard for enough is like 9.5 or 9.9 out of 10. That's the standard for enough. But for probable cause, the standard is 1 out of 10. Is the standard enough? And, a hearsay statement by itself is not enough. But again, it's the accumulated form. It's the combination of different things. It's this person saw track marks. This person saw the kids being neglected. This person heard that, that Nick would get drunk and loaded and, drive with the kids. This video shows him doing something that seems to be drug use. Based on my training and experience, that seems to be what I've seen, right? And so the question is whether or not it's combined is enough to reach the 1 out of 10 standard. And that's the relevant legal question. So that's the correct framework under the relevant law. So it's not very much. You're just trying to find objective indicia that suggests that the person has done a crime. And, that's what you're trying to get to. The losing massive amounts of weight, right? Also, the cop talked about, it's like, yes, I saw him losing lots of weight. That might be indicative of drug use, right? So, any one of these things by itself isn't sufficient, nor does it have to be. And even at trial, it would be unlikely for you to have the piece of evidence that proves the thing. That's unlikely. More common is the picture together. You're trying to build a puzzle. It's like, how much of the puzzle do you need to fill? How much of this jigsaw puzzle do you need? How many pieces can you have missing out of the puzzle and it still be enough? If it's a 100-piece jigsaw puzzle at trial, 95 out of 100 pieces probably is enough. It's like, yeah, we have a few pieces missing, but we got the picture. For probable cause, 10% is probably enough. It's like, yeah, we got a vague idea of what's going on here, right? So yeah. Yeah, one step above gut feeling. A little bit. I mean, it's a little bit tongue in cheek, but maybe 2 steps above gut feeling. But yes. New York Renal MD says, isn't it true the police could be mistaken as long as their conclusions were reasonable and search yields drug, search is legal? Well, not quite that. No, you can't quite get to because we found drugs, the search was legal. No, that doesn't work. So not quite. The question would be, you can't get lucky, right? The police can't get lucky and the defense can't get lucky, any more than a doctor can get lucky. If the doctor, did the surgery with no evidence, believing there to be a medical condition, and it turns out there was in fact the medical condition, but the doctor didn't have enough evidence at the time, that wouldn't necessarily be sufficient either. It's like, you can't necessarily just get lucky. You need to be able to have an evidentiary picture that justifies the thing in the first place. So, which is true for any kind of professional. Just because the professional gets lucky doesn't necessarily mean that they have the basis to do the thing. So, and that's also true incidentally if they didn't find drugs, because the question isn't the warrant turning up what we thought to turn up doesn't in itself determine whether or not the search was reasonable. That's not enough, because we may not find anything, which happens sometimes in a search. We don't find anything. So, it's not quite, because we found drugs. It's, did we have enough evidence to have a reasonable basis to which to conclude that there was sufficient evidence that's objective that this person has committed crime, and also that we can find drugs in this place. So that's a little bit more. Stop trying to talk fast. I'm not trying to talk fast, Bobby. That's just how I talk. Why would I be? That doesn't make sense. That's just how I talk. But I'll try to slow down some if it's too fast. What else can I answer for you? You're not too fast? Cool. If the state doesn't address every claim in their response, or they're waiving whatever they ignore, it could certainly be interpreted that way. Yes. The state would be well advised to address everything that the defense mentions. Yes. Hamilton Burger for $2 Canadian says, at Frank's hearing, is stream authentication needed? If your question is, will it be streamed at all? I don't know the answer to that question. The omnibus hearing obviously wasn't streamed, so I don't know whether or not it will be streamed or not. So I can't speak to that. Can I ask me for my thoughts on a preliminary injunction in CRPA versus LASD? No. California will be required to issue non-resident CCW permits? Okay. No, I have no thoughts on that issue at this time. I've done no prep for it. And I'm not obviously going to try to find, I'm obviously not going to try to bring up a completely different case and try to understand it and explain it in real time. So no. Did I see the machine gun case thrown out in Discord? I did with the Fifth Circuit. I believe it's on my list of stories to record eventually. Today's story I'm going to record is in relation to the Karen Reed lawsuit. As a result of Nick's allegations, do I have a falling out or not speaking with Nick? Not as far as I'm concerned, no. I can't speak to how Nick feels about it, but I'm trying to provide the best legal analysis I can, because that's what I do. I try to provide the best legal analysis I can, which doesn't necessarily mean I will always be right, but I do my best to provide the most reasonable, objective legal analysis I can. And it's like, well, this is what I think is the correct legal answer. So as far as I'm concerned, no, I hope there's been no falling out. And I hope on some level, although I can't obviously speak to it, but I hope on some level that Nick appreciates on some level that I'm trying to provide a legally sound answer. You know, he may or may not disagree with me. His lawyers may or may not disagree with me, but I hope that he appreciates that I'm trying to be as reasonable and objective as possible about it. And, you know, perhaps it's not what he wants to hear, but then again, sometimes I can't always tell people what they want to hear. And I may be proven wrong in the end. Of course, that sometimes happens, but what can you do? Watermelon says, pop quiz. You're facing murder trial. 3 choices, Legal Eagle or Barnes or you as a lawyer. I'll take Legal Eagle. I'll take Legal Eagle. If my choices are Legal Eagle, Barnes, or me as a lawyer in my own murder trial or take a blind plea deal, I'll take Legal Eagle. Yeah. Yeah. Yeah, and I could be wrong. You know, it's like I've been pretty critical of this idea from the start. It's like, you know, this search warrant seems reasonably sound. You know, that's why I said it seems reasonably sound on its face. I continue to believe it's reasonably sound on its face. I think that like attacking the warrant is going to be incredibly difficult at best. You know, this is trying to pick at things, which is kind of what you would expect, trying to pick at things to try to make it go away. But, you know, it doesn't seem like the kind of situations in which you would expect to be able to suppress on a Franks hearing. Typically, the kind of things you're looking for is much more of a direct contradiction. You're typically looking, or something that is just like, something that's just like an intolerable, intellectually inconsistent thing. So it's like, okay, it was rendered private rather than removed. It's like, okay, no. Or it was a re-uploaded video with a watermark on it. It's like, you know, it's just like, it feels much more like, you know, a little bit more petty and feels more like, you know, nibbling around the edges than, you know, the direct contradiction, which would be more typical in a Frank situation. So I don't have a lot of high hopes for this, but, you know, yeah. Something that shocks the conscience. Yeah, a little bit more and black. That's kind of like more what you would expect. Something that shocks the conscience. Yeah, that's more what you would expect in a Frank's kind of hearing. So, yeah. So I don't have a lot of high hopes for this. I think as part of a criminal defense, you can pick at things whenever you can. Well, generally speaking, I would agree, although I might disagree in the extreme. But generally speaking, a lawyer must provide zealous representation to their client. That's like the essential duty of a lawyer, is to provide zealous representation. And so as a general rule, or as even a 95% rule, a lawyer would try to find any valid legal argument that is non-frivolous to argue. So I don't think these arguments are frivolous. I just don't think they work. So, that's my view. So I don't mind the lawyer arguing these things. I just don't think they work. I think the fact that the lawyer made these arguments kind of shows, unfortunately, this is all the lawyer has to work with. Because if the lawyer had better arguments, presumably the lawyer would have presented them. So this is all the lawyer has to work with, which is not great. But sometimes that's the situation. You as a lawyer just have to deal with the reality that you have. You can't necessarily make everything magically work. I feel like we need a higher bar for a home warrant. Okay, fair enough. Maybe we do need a higher bar, but I'm just trying to describe the state of the law. So maybe we do need a higher bar, but that's the state of the law. So especially when drugs, yeah, especially with drugs, the war on drugs has been has not necessarily been good to the Fourth Amendment. Yeah, the war on drugs has not necessarily been good to the Fourth Amendment. So the Fourth Amendment may have been weakened by the war on drugs, but yeah. All right. The war on drugs has been a massive catastrophe. Tony P, that may very well be true. Yeah, that is, if you want to critique the war on drugs, if you want to critique the state of the law, then, fair enough. But, yeah, it is what it is, unfortunately, for the moment. So, yeah. Thank you very much, District Tribute. I try very hard to keep my commentary as legally sound as possible, because I want to try to get the law as correct as I can. And so try to reasonably forecast, what I think is likely to occur. What are my thoughts on Bitcoin? I don't know that I have any particular thoughts on Bitcoin. That's a strange question. I don't necessarily think it's a good investment vehicle. But other than that, I don't necessarily have any particular thoughts. Preliminary hearings aren't supposed to be broadcast per Minnesota statute. Okay, fair enough. So I can't speak to whether or not an eventual Frank's hearing will be broadcast or not. So I don't know. But if not, then we'll do the transcript of it. 655 says, thanks, Civil. What's my thought on time blindness, girl? I have no idea what you're referring to. Do you mean the girl who, like on TikTok, who was suggesting that time blindness is a part of her culture? It's a strange question. It's very off point. Nice hat. Thank you. All right. I think what I'm going to do is I'm going to go ahead and wrap up the stream, and then I'm going to record this Karen Reed stream. So if you like to do that, that's fine. It's a members only stream. It should hypothetically redirect you there automatically. So if you'd like to, you can hit that beautiful, beautiful join button and watch me do a record and a basic edit, because I like to kind of share that behind the scenes stuff. So today I'm going to do a recording on the Karen Reed civil suit, her being sued for the wrongful death relating to striking John O'Keefe and the drunkenness and all the rest of it. So if you want to do that, April filed a motion to dismiss. I'm sure she did. Yeah, I think I saw that April filed the motion to dismiss. But, I'm just going to try to stick to Nick's case for the moment. Probably not discuss the other cases too much. But yeah, I saw that April filed a motion to dismiss, which of course you'd expect. Well, I might cover it then. Maybe I'll cover it. I don't know. I don't know if I necessarily want to get into Kayla's case. I don't know if I necessarily want to get into April's case. I don't know. I guess I could. Maybe I should. I don't know. I'll think about it. But for the moment, I'm going to go ahead and bounce over there. So if you want to hit the beautiful, beautiful join button, that'd be cool. Help support the channel. It would be appreciated. And we're going to do a recording session over there and all the rest of it. So I'll do that. Hey, you think she's guilty? Lol. I think she's incredibly not guilty. I think she's insanely not guilty, but you know, what can you do? I've been on Civil Law. Until later, my friends. I hope all is well. Cheers, my friends, for now, and goodbye.